If you've been looking for a comprehensive report about Title 16 of the Revised Corporation Code, Investigation, Offenses, and Penalties, you've come to the right channel. By the way, I am Rochelle Gradil, and let me introduce you to my team. We have here Alexis Jan Legaspi, Valerie Grulla, Alison Parangipang, and Jessica Rota, who will also report some sections of this code. Now, let me begin with Section 154, Investigation and Prosecution of Offenses. The Commission may investigate an alleged violation of this code or of a rule, regulation, or the order of the Commission. This section grants the SEC the authority to conduct investigation when there are allegations or evidence of violations such as fraud, misrepresentation, or failure to meet legal requirements. And if it finds sufficient evidence, it can initiate administrative sanction or file criminal complaints with the Department of Justice for prosecution. This section also underscores the SEC's role in ensuring compliance with the corporate regulation and maintaining accountability in corporate practices. One of the power of the SEC is also stated in Section 155, Administration of Oaths, Subpoena of Witnesses and Documents. The SEC, through its designated officer, may administer oaths and affirmation, issue subpoena and subpoenas duces tecum, take testimony in any inquiry or investigation, or perform any other acts that is necessary to the proceedings or investigation. This enables the SEC to compel individuals to take testimony under oath and produce relevant documents which may be critical in determining whether there has been a violation of corporate laws. If a person fails to comply with a subpoena, the SEC can seek court assistance to ensure compliance. This section also strengthens the SEC's investigative and adjudicative capabilities by ensuring it has the legal tools to gather evidence, hold corporations and individuals accountable, and enforce corporate governance standards effectively. Another power is to issue cease and desist order. According to Section 156, whenever the Commission has reasonable basis to believe that a person has violated or is about to violate the rule, regulation, or the order of Commission, it may direct such person to desist from committing the act constituting the violence. This provision also empowers the SEC to issue cease and desist order as a preventive or corrective measure to prevent any other acts that violates the rule, regulation, or any other related laws. This authority also allows the SEC to intervene promptly whenever a corporator engages in any other acts that are harmful, illegal, or detrimental to the public, investor, or corporate system. Meanwhile, a cease and desist order can be issued ex parte, in which SEC can act without prior notice if the violation poses significant threat or damage. This ensures quick action and prevent further harm while the case is being investigated. However, the SEC must justify its action and comply with due process, allowing the affected party to contest the order through a hearing or an appeal.
Section 157, Contempt. This provision reads, any person who, without justifiable cause, fails or refuses to comply with any lawful order, decision, or subpoena issued by the Commission shall, after due notice and hearing, be held in contempt and fined in an amount not exceeding 30,000 pesos. When the refusal amounts to clear and open defiance of the Commission's order, decision, or subpoena, the Commission may impose a daily fine of 1,000 pesos until the order, decision, or subpoena is complied with. This section is important because it ensures that the Commission's orders and subpoenas are taken seriously. For example, imagine a corporation receives a subpoena to provide financial records but refuses to comply. Under this provision, the Commission can impose a fine up to 30,000 pesos for non-compliance. If the refusal continues, a daily fine of 1,000 pesos can be imposed, forcing the corporation to eventually comply. This ensures that entities cannot ignore the Commission's authority without facing consequences. It is designed to promote transparency and accountability in corporate governance. Now, let us discuss Section 158, which deals with the administrative sanctions. It reads, if, after due notice and hearing, the Commission finds that any provision of this code, rules or regulations, or any of the Commission's orders has been violated, the Commission may impose any or all of the following sanctions, taking into consideration the extent of participation, nature, effects, frequency, and seriousness of the violation. First, imposition of a fine ranging from 5,000 pesos to 2 million pesos and not more than 1,000 pesos for each day of continuing violation, but in no case to exceed 2 million pesos. Second, issuance of a permanent cease and desist order. Third, suspension or revocation of the certificate of incorporation. And lastly, dissolution of the corporation and forfeiture of its assets under the conditions in Title 14 of this code. This provision gives the Commission the power to penalize corporations for violations of this code. For example, if a company repeatedly fails to comply with reporting requirements, the Commission can impose a fine ranging from 5,000 pesos to 2 million pesos, depending on the severity of the violation. If the violation continues, an additional fine of 1,000 pesos per day can be added. Furthermore, the Commission can issue a permanent cease and desist order to stop the company's illegal activities, and in extreme cases, the company's certificate of incorporation can be revoked. If the company's actions are severely detrimental, the Commission can even dissolve the corporation and seize its assets. This ensures that businesses operate in compliance with the law, protecting stakeholders and the public. Next, let us turn to Section 159, which deals with the unauthorized use of a corporate name. This section reads, "The unauthorized use of a corporate name shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos. For example, if a new company starts using a name that is identical or too similar to an already established corporation, it can be penalized under this section. The fine for this violation ranges from 10,000 pesos to 200,000 pesos, depending on the gravity of the situation. This provision protects corporations' identities and prevents fraudulent behavior, such as misleading consumers or confusing the public by using a name that already belongs to a legitimate company." Now, let's discuss Section 160, which deals with the violation of disqualification provisions for corporate officers. This section reads, "When, despite the knowledge of the existence of a ground for disqualification as provided in Section 26 of this code, a director, trustee, or officer willfully holds office or willfully conceals such disqualification, such director, trustee, or officer shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos at the discretion of the court, and shall be permanently disqualified from being a director, trustee, or officer of any corporation. When the violation of this provision is injurious or detrimental to the public, the penalty shall be a fine ranging from 20,000 pesos to 400,000 pesos. This section prevents individuals who are disqualified from holding certain corporate positions from willfully remaining in office. For instance, if a director is convicted of a crime that disqualifies them from holding office and they conceal this fact or continue to serve, they can be fined between 10,000 pesos and 200 pesos. If the violation causes public harm, the fine can go up to 400,000 pesos. Additionally, they will be permanently banned from holding any directional, trustee, or officer position in the future.
Good day, everyone. I am Valerie Argulia, and let us now discuss Section 161, which addresses the violation of duty to maintain records, allow inspection or reproduction, and the corresponding penalties. This section provides that the unjustified failure or refusal by the corporation or by those responsible for keeping and maintaining corporate records to comply with Sections 45, 73, 92, 128, 177, and other pertinent rules and provisions of this code on inspection and reproduction of the records shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos at the discretion of the court, taking into consideration the seriousness of the violation and its implications. When the violation of this provision is injurious or detrimental to the public, the penalty is a fine ranging from 20,000 pesos to 400,000 pesos. The penalties imposed under this section shall be without prejudice to the Commission's exercise of its contempt powers under Section 157 hereof. This section ensures compliance with laws on maintaining and providing access to corporate records. Non-compliance leads to fines ranging from 10,000 pesos to 200,000 pesos, or up to 400,000 pesos if public harm occurs. For example, if a corporation refuses to let a shareholder inspect financial records under Section 73 without a valid reason, it can be fined. If this refusal misleads the public about its finances, the fine will be higher. Next is Section 162, which pertains to the willful certification of incomplete, inaccurate, false, or misleading statements or reports and the associated penalties. This section provides that any person who willfully certifies a report required under this code, knowing that the same contains incomplete, inaccurate, false, or misleading information or statements, shall be punished with a fine ranging from 20,000 pesos to 200,000 pesos. When the wrongful certification is injurious or detrimental to the public, the auditor or the responsible person may also be punished with a fine ranging from 40,000 pesos to 400,000 pesos. This section penalizes those who intentionally certify false or incomplete reports, with fines starting at 20,000 pesos and increasing to 400,000 pesos if public harm occurs. For example, if an auditor signs a financial statement showing fake profits to attract investors, they can be fined up to 400,000 pesos if the public suffers losses from the deception. Following that is Section 163, which focuses on independent auditor collusion and the corresponding penalties. This section provides that an independent auditor who, in collusion with the corporation's directors or representatives, certifies the corporation's financial statements despite its incompleteness or inaccuracy, its failure to give a fair and accurate presentation of the corporation's condition, or despite containing false or misleading statements, shall be punished with a fine ranging from 80,000 pesos to 500,000 pesos. When the statement or report certified is fraudulent or has the effect of causing injury to the general public, the auditor or the responsible officer may be punished with a fine ranging from 100,000 pesos to 600,000 pesos. This section ensures auditors act independently and accurately, with penalties ranging from 80,000 pesos to 600,000 pesos for colluding to approve false financial statements. For example, if an auditor falsely certifies a corporation's financial report to hide huge losses and the report harms investors or the public, the auditor will face higher penalties. We now proceed to Section 164, which pertains to obtaining corporate registration through fraud and the penalties associated with such actions. This section provides that those responsible for the formation of a corporation through fraud or who assisted directly or indirectly therein shall be punished with a fine ranging from 200,000 pesos to 2 million pesos. When the violation of this provision is injurious or detrimental to the public, the penalty is a fine ranging from 400,000 pesos to 5 million pesos. This section penalizes those who form corporations through fraud, with fines starting at 200,000 pesos and increasing to 5 million pesos if fraud harms the public. For example, if someone submits fake documents to register a corporation, they could face these fines, especially if their action harm investors or consumers.
Hello, I am Jessica Birota, and I will be discussing 4 sections of the penalties under the Title 16 of the Revised Corporation Code. Section 165, Fraudulent Conduct of Business. This section targets corporations that engage in fraudulent conduct as part of their regular business operations. So this involved deceptive practices such as misrepresentation, falsifying of financial statements, or any act designed to deceive stakeholders, including investors, clients, or government agencies. So the penalties if the corporation engages in fraud without harming the public, the fine ranges from 200,000 pesos to 2 million pesos. But if the fraud harms the public or endangers the public, for instance, misleading the investors or the consumers, the fine will increase to 400,000 to 5 million pesos. So this higher penalty reflects the seriousness of the public harm caused by fraudulent conduct. Fraudulent activities can range from minor misstatements to major fraudulent schemes. So in these cases, the law aims to penalize not just the fraudulent individuals, but also the corporation itself, as corporations can have widespread and lasting effects on markets and society. So the emphasis on the public harm, that if the fraud damages the public's trust or safety, the fines are significantly more severe. Section 166, Acting as Intermediaries for Graft and Corrupt Practices. So this section aims to target scenarios where corporations act as conduits or channels for illegal activities such as bribery or kickbacks. So for an instance, a corporation might be used to funnel money or resources to government officials in exchange for favors or contracts. So the penalties if found involved in facilitating corrupt activities, so the corporation faces fines ranging from 100,000 pesos to 5 million pesos. So if any of the corporation's directors, officers, employees, agents, or representatives are directly involved in graft and corruption, the corporation can also be held liable if it has failed to implement anti-corruption safeguards. So corporations as legal entities can be held liable for corruption even if the illicit activities or practices are carried out by their employees or partners, especially if they fail to implement safeguards like internal audits, transparent accounting, and a code of ethics. So the law emphasizes the importance of preventive measures and the presence of the prima facie evidence, which shifts the burden to corporations to demonstrate their efforts to prevent corruption. So without these measures, the corporations are likely to be held liable or accountable for corruption activities. Section 167, Engaging Intermediaries for Graft and Corrupt Practices. So this section focuses on situations where a corporation deliberately appoints or engages intermediaries such as contractors or agents to carry out illegal actions on its behalf. So these intermediaries may be hired to bribe officials, conceal illicit financial transactions, or otherwise engage in corrupt practices for the corporation's benefit. So the penalties if the corporation is found guilty of engaging intermediaries for graft and corruption, they will face a fine ranging from 100,000 pesos to 1 million pesos. So the corporation is held responsible for any corrupt activity carried out by these intermediaries, especially if it benefits the corporation. So the corporations might hire third parties or agents to act on their behalf to avoid direct involvement in illegal practices. However, this section makes it clear that a corporation cannot evade liability by using intermediaries. Even if the corrupt activities or actions are carried out by external agents, the corporation will still face penalties if it benefits from those actions. So this provision is important because it discourages corporations from outsourcing illegal activities to hide their involvement. Section 168, Tolerating Graft and Corrupt Practices. So this section targets corporate leadership, specifically directors, trustees, and officers who knowingly tolerate or fail to act against graft and corruption within their organization. So the section is aimed to those in leadership roles who, despite being aware of illegal practices, do not take appropriate action to stop them. So the penalties if the directors, trustees, or officers who knowingly allow or tolerate graft and corruption will be fined between 500,000 pesos to 1 million pesos. So corporate leaders have a responsibility to actively address corruption by reporting misconduct, conducting internal investigations, and implementing corrective measures. So the law emphasizes that leadership accountability is crucial in corporate governance, as failing to intervene when misconduct is known not only enables corruption but also erodes the corporation's integrity and public trust. So proactive measures by leaders are essential to uphold ethical standards and prevent reputational damage. Again, I am Jessica Virota, and that would be all for my part.
So good day everyone, I am Alexis John A. Legaspi, and let's continue our discussion. We will now proceed on section 169 of this title, which is all about retaliation against whistleblowers. So section 169 states that a whistleblower refers to any person who provides truthful information relating to the commission or possible commission of any offense or violation under this code. Any person who knowingly and with the intent to retaliate commits acts detrimental to a whistleblower, such as interfering with the lawful employment or livelihood of the whistleblower, shall, at the discretion of the court, be punished with a fine ranging from 100,000 pesos to 1 million pesos. So this section safeguards whistleblowers, individuals who report corporate wrongdoing from retaliation. It ensures they can report violations truthfully without the fear of adverse consequences, such as losing their job or income. If retaliation is proven, offenders may face significant fines stated in this section. This provision promotes transparency, accountability, and ethical conduct within corporations by protecting those exposing unethical practices. So for example, employees report their company for falsifying financial records to evade taxes. Afterward, the employer demotes them and cuts their salary. This action is retaliatory and violates section 169 of this code, and thus, the whistleblower may file a complaint and the court shall impose a fine on the employer, ensuring justice and deterring future retaliatory actions. Next is section 170, which talks about the other violation of the code. Violation of any of the other provisions of this code or its amendment not otherwise specifically penalized therein shall be punished by a fine of not less than 10,000 pesos but not more than 1 million pesos. If the violation is committed by a corporation, the same may, after notice and hearing, be dissolved in appropriate proceedings before the commission, provided that such dissolution shall not preclude the institution of appropriate action against director, trustee, or officer of the corporation responsible for said violation, provided further that nothing in this section shall be construed to repeal the other causes for dissolution of a corporation provided in this code. Liability for any of the foregoing offenses shall be separate from any other administrative, civil, or criminal liability under this code and other laws. This section addresses violations of the code that are not explicitly penalized. It imposes fines ranging from 10,000 to 1 million pesos, and it grants the Securities and Exchange Commission the authority to dissolve corporation for severe breaches. So it ensures accountability, especially in cases where directors, trustees, or officers are responsible for violation. Importantly, it allows for separate liability, meaning penalties under this section do not exempt violators from other legal consequences such as civil or criminal charges. For instance, a corporation is found operating without renewing its SEC registration, which violates the code. The SEC shall conduct a hearing and impose a certain fine. Additionally, the corporation is dissolved and its directors face further legal action for negligence. Next is section 171 of this code that deals with the liability of directors, trustees, officers, or other employees. It states that if the offender is a corporation, the penalty may, at the discretion of the court, be imposed upon such corporation and or upon its directors, trustees, stockholders, members, officers, or employees responsible for the violation, or indispensable to its commission. So this section ensures that individuals behind corporate violations are held accountable. If a corporation commits an offense, penalties may extend not just to the entity but also to the directors, trustees, officers, stockholders, or employees responsible for or indispensable to the violation. This provision prevents corporate leaders from hiding behind the entity to avoid personal liability and ensures that decision makers or participants in misconduct face appropriate consequences. A good example is when a corporation engages in fraudulent securities trading. Investigations revealed that the CEO and a director orchestrated the scheme. Under the Section 171, penalties are imposed not only on the corporation but also directly on the CEO and director, ensuring individual accountability for their roles in the fraud. Lastly, we have Section 172, which talks about the liability of aiders and abettors and other secondary liability. It states that anyone who shall aid, abet, counsel, command, induce, or cause any violation of this code or any rule, regulation, or order of the Commission shall be punished with a fine not exceeding that imposed on the principal offenders, at the discretion of the court after taking into account their participation in the offense. So this section holds individuals who assist, encourage, or contribute to corporate violations accountable. Aiders and abettors may include employees, consultants, or external agents who enable the offense by providing advice, assistance, or support. The court can impose fines up to the amount levied on the principal offenders based on the extent of their involvement. This provision emphasizes shared responsibility, ensuring that those who contribute to misconduct cannot evade liability. An example would be a corporate lawyer who advises their client to falsify financial disclosure to mislead investors. Although the corporation faces penalties as the principal offender, the lawyer is also fined under Section 172 for the counseling and enabling the violation. This enforces accountability for secondary participants in corporate wrongdoing. So this concludes our discussion of Title 16 of the Revised Corporation Code, which includes investigations, offenses, and penalties. I hope this video lesson helps you understand and gain more knowledge about this topic. Once again, thank you and have a good day.